Hello and welcome to a fresh episode of Legal Wrangle. In today's episode, we will present before you some latest judicial developments which have taken place in the field of GST. For this, we have selected some decisions rendered by various high courts touching upon various provisions of the GST Act. The petitioner company had earlier approached the High Court seeking an update upon the constitution of the appellate tribunal under the GST regime. On the initial date of hearing, the counsel representing the GST Council was unable to state as to whether or not the appellate tribunal had been constituted or if the government had made any progress in this regard. Hence, the High Court posted the matter for further hearing.
In the current hearing, the High Court considered through the affidavits by the government's counsels but found there to be non-concrete proposal to set up the appellate tribunal. From the affidavit, the court also observed that a recommendation had been made to establish a bench of the tribunal in Lucknow. However, the court found such proposal then contrary to the directions given by the Apex Court in Madras Bar Association versus Union of India. Another wherein it was held that the appellate tribunal under GST was to be set up at the place where the principal bench of the High Court is located.
Thus, the court noted that the proposal mentioned in the affidavit submitted by the government's counsel appeared to be another delaying tactic. It observed that the petitioners were being denied right of appeal and also that the central and state governments were quick to make recovery of tax arrears. Hence, it opined that a litigant could not be left high and dry without any remedy merely because the government was unable to set up appellate fora. Hence, it directed both the centre and state governments to file affidavits giving a definite cut-off date by which the tribunals would be created. Thus, it posted the matter for further hearing. Let's proceed to our next case.
The petitioner is a car dealer. The issue at hand in this case pertains to the correct valuation methodology for ascertainment of GST on tax collected at source under the provision of the Income Tax Act 1961. The petitioner company sought to stay on the operation of seeking stay in the operation of serial number 5 of the clarification issued White Circular 76/50/2018 GST dated 31st December 2018.
The High Court then referred to Section 15 of the CGST Act pertaining to the value of goods and services and which defines how the value of supply is to be reckoned. It also mentions that the value of supply of goods or services or both would be the transaction value, which is the price actually paid or payable for such supply where the supplier and recipient of supply are not related and where the price is the sole consideration for the supply.
The court also observed that Section 15(2) mandates that the supply would include any taxes, duties, cess, fees and charges levied under any other law in force. It agreed with the petitioner's contention that Section 15, subsection 2, subsection A is an expensive provision. The petitioner also submitted that the 1% amount collected by a dealer from the purchases of a car worth above Rs 10 lakh under Section 206C of the Income Tax Act cannot be treated as an integral part of the value of goods, services supplied by it. The petitioner also claimed to only act as an agent for the state in collecting income tax, which would eventually go to the vehicle purchases credit.
The High Court opined that the petitioner had raised a prima facie issue which warranted the court's attention. It then referred to the decision of the Apex Court in Commissioner of Customs Import Mumbai versus Messrs Dilip Kumar and Company and others, wherein it was held that any ambiguity in the taxing provision was to be resolved in favor of the state. Thus, the court held that the matter required deeper adjudication before a decision could be taken. Hence, it issued directions to the department to not act upon the clarifications at serial number 5 pending disposal of the present writ. Incidentally, the CBIC has issued a corrigendum to the circular number 76 of 50 of 2018 GST dated December 31, 2018 on the 7th of March 2019, substituting the clarification offered against serial number 5, which was the subject matter of the petition, and revising its earlier stand. inasmuch as it is clarified that for the purpose of determination of value of supply under GST, the tax collected at source under the provisions of the Income Tax Act 1961 would not be includable, as it is an interim levy not having the character of tax. Apparently, since the above substituted clarification is by way of a corrigendum, it is felt that the same would be retrospective in operation. Let's proceed to the next case.
The petitioner company was aggrieved by the dismissal of its appeal by the appellate authorities. The provision of Section 107 of the UP GST Act mandate that first appeal is to be filed within a period of 3 months from the date of communication of order. It also mandates that the delay can be condoned for a period of 30 days from the expiry of the regular period of limitation. In the present case, the appeal had been filed after a delay of about 9 days beyond the condonable period, hence the appeal was dismissed as being time barred.
The petitioner pleaded that if the remedy of appeal is held to be non-existent, the High Court may exercise its writ jurisdiction. The court further observed that the matter required consideration and so gave 4 weeks' time to the Revenues Council to file rejoinder affidavit. Thus, it listed the matter for further hearing. However, it also directed the petitioner to pre-deposit 50% of the disputed tax amount and also furnish security for the balance amount. It directed that subject to payment of the same, further recovery proceedings would be stayed. Let's now proceed to the last case.
The petitioners herein are individuals who had been charged with issuing fake invoices without actual supply of goods, with intent to enable other registered taxpayers to fraudulently avail input tax credit. The department alleged that such activities caused huge loss to the economy. Thus, the petitioners were charged with offences committed under Section 132, subsection 1, subsection B of the CGST Act and were issued summons. The petitioners then sought for anticipatory bail under Section 438 of the Code of Criminal Procedure as they apprehended arrest.
The High Court observed that a close reading of the provisions under Section 132, 138 and 139 of the CGST Act clarified that the maximum punishment provided under the CGST Act is 5 years of imprisonment and fine. It also noted that the magnitude of the alleged offence could also be taken into consideration. Thus, it noted that these provisions did not prescribe punishment by way of imprisonment for life. The court also pointed out that these provisions in fact enabled the relevant authority who initiated such proceedings with the power to compound the offences.
The court noted that the only aspect which had to be considered while granting anticipatory bail is whether the participation of the petitioners can be secured for investigation or trial proceedings. Hence, the petitioners were granted anticipatory bail. However, the court also directed furnishing of personal bond for a sum of rupees 5 lakh along with the 2 sureties of similar amount. They were also directed to not to leave the country without obtaining prior permission and also to desist from tampering with evidence or indulging in such criminal activity.
This brings us to the end of today's episode of Legal Wrangle. Please stay tuned to TIOLtube.in for our upcoming videos on different areas of taxation law. Please also feel free to share your views with us at editor@tiol.in. Thank you for watching and have a pleasant day.